In today's video, I am focusing on skilled workers whose leave have been revoked or curtailed and usually have been given 60 days under the immigration rules. So under the immigration rules, several factors could lead to revocation of a skilled worker or a dependent visa. Usually will be because the sponsor have lost, or the sponsor has lost their sponsorship license, or the sponsor has reported that they are no longer sponsoring you, or that your spouse who you came here with, which is your dependent partner, the main applicant, may have reported that the relationship has soured or separated, or that there has been a divorce. Now, when you're given 60 days, really, you can make an application within the 60 days. Once an application is made, on the date of the application, you will be protected under the law called Section 6C of the 1971 Immigration Act. But what can you do? If your leave has been revoked and given 60 days, you can also go and look for a sponsor. I have heard many stories of sponsors not having COS. However, the latest guidance for skilled workers and work permit holders is that if your sponsor has applied for a COS and they have not been given the COS yet, or if it's a new sponsor who has applied for a sponsor license and it's not been granted, Home Office guidance says that in that case, if they can show that the delay is coming from the Home Office, they may hold on to your application. So you can make an application in that situation without a COS number or code. The second part is that you can marry someone here, especially if your relationship is broken down. If you've met a new person who is settled here, either as an EU national with settled status, or somebody who is a foreigner with indefinite leave to remain, or a British citizen who lives and is settled in the UK, you can make an application through them. So you can make a family application. The third factor which you can rely on that many people do not realize is that as a skilled worker and a skilled worker dependent, you can apply to stay here as a student. So you can, once you've made an application and you've been given a CAS, you can make an application within the 60 days. The other thing that you can do is that you can also self-sponsor yourself. I must, however, advise you that self-sponsoring is a very complex area and you need a lawyer to assist you because of the short duration of the curtailment or the revocation. Again, you can do either a global talent, which allows you, if you've got a specific talent, which you can show that you can do certain particular work, then you can do. Or you can do a scale-up or Innovator Founder. Both are self-sponsoring, but they are in different categories. Let me reiterate. 1, you can make an application without a COS if your new sponsor has applied for a COS or registering a new company and license has not been granted yet. That is what the Home Office guidance note says, and you can see on the scroll that that's exactly what it says. 2, you can switch to a family visa, which is a spouse of a British citizen or a person who is settled here, or an EU national with pre-settled or settled status. You don't have to leave the UK. If you're a Ghanaian or an African whose customary marriage is legal in the UK, you can conduct the marriage in your country, have it registered properly, and you can use it here. If you're a Ghanaian, you can contract a customary marriage. If it's properly registered, and then the Ghana High Commission gives you a letter, you can use that to make your application. You don't have to leave the UK, either as a dependent or as the main person. I repeat again, you can go to school, so you can become a student. You can do scale up, or you can do innovator visa, or a global talent, or you can do self-sponsorship. They are all within they must all be within your ability to achieve that. My advice to all of you is that once you've been given the 60 days, you must start working from day 1. My last advice is that I have noticed that some of you who came here because you were assisted by an agent. You haven't changed your email address. So when the Home Office sends the revocation letter, you don't receive it. I had a lady who came in to see me yesterday. She was sent a revocation letter in January 2025. She only saw it in July 2025. By that time, the 60 days had passed, and clearly there was absolutely nothing she could do because the email address she gave them, she said she couldn't access the email address. You've all got electronic visas. So if your email is changed, your address is changed, your phone number is changed, go on the system and change your details. That way, when the Home Office revokes your visa, you will receive the notification. I hope this is helpful to someone.